Hi, and welcome to this latest immigration law update video. This is the second in a series of videos I'm doing going through the reported decisions for 2020 from the upper tribunal. So today we're going to look at February 2020. And February 2020 was a very busy month, and there's a load of reported decisions covering some really important topics, and particularly three cases which look at the whole issue of right of appeal. So we'll get into those now. What I've done is I will stick the citations below the video with the links, and also on Chamber's website I'll put my PowerPoint if you need a copy of those. So let's get into the decisions. The first one is Aziz. Aziz, this is the first case when looking at sort of the whole issue of rights of appeal, because Aziz was a tax discrepancy case. This was refused and there was an appeal. Mr. Aziz also has children, and that was subject of the appeal. The appeal was dismissed on all grounds. Permission was refused by the First-tier Tribunal and the upper tribunal, and then there was a CART JR. People will know that a CART JR is a JR of a refusal of permission to appeal. And whilst the CART JR was being pursued, the Secretary of State granted leave on Article 8 grounds to the family as a whole. Now, the CART JR, permission was granted, and the refusal of permission from the upper tribunal was quashed, and then the case came back and permission was formally granted in the upper tribunal. And when the case came before the upper tribunal held that the effect of the grant of leave was that the appeal should be treated as abandoned under Section 104. Now, actually, at the time leave was granted, the appeal wasn't pending because permission had been refused. But as soon as the High Court quashed the refusal of permission, the appeal was pending again, and the grant of leave meant that it was officially abandoned under Section 104. Now, the sting in the tail to this is that the upper tribunals say, well, hang about, under your duty of candour in the JR, solicitors should have informed the High Court that leave had been granted and that removal was no longer imminent. And therefore, we're going to report you effectively to the High Court to see if they want to take action, because you should have disclosed that to them. So a bit of a procedural sting in the tail in Aziz, so one to watch out for. The next case, really interesting case of Birch. It has two really interesting points in it. The appellant, Miss Birch, came to the United Kingdom in 1999 as a visitor, then with leave as a student. Leave ran out in 2001. Now, in 2007/2008, she encountered somebody who introduced her to somebody posing as an immigration officer and paid £3,000 for what she thought was indefinite leave to remain. Now, the important point here is that everybody, including the Home Office, accepted that she'd been genuinely deceived and that she was innocent in all of this. That's really important. Her Article 8 appeal was dismissed by the First-tier Tribunal. On appeal to the upper tribunal, they held, following Agiarco, paragraph 53. Now, Agiarco at paragraph 53, Lord Reid is talking about certain situations where Article 8 can be engaged, even though there's no insurmountable obstacles. And one of the things he talks about is where somebody has a misapprehension about their ability to maintain family life in the United Kingdom. And they held that these observations in Agiarco apply in Miss Birch's case, because between 2007 and 2015, when it became apparent that she'd been deceived and it was a counterfeit, she believed that she had indefinite leave to remain, and that affects the balance in Article 8 terms, and was enough to find a material error of law in the decision of the First-tier Tribunal. So that's point one in relation to the relevance of a misapprehension about your ability to maintain family life in the United Kingdom and its relevance to Article 8. Point two is about the new matter provisions, because by the time Miss Birch had her case reconsidered by the upper tribunal, she'd now reached 20 years in the United Kingdom. The Secretary of State argued, well, hang about, that's a new matter. Section 85(5) of the 2002 Act applies. You can't consider it without our permission. The upper tribunal, and Mr. Ockleton here says, well, no. Section 81 defines what the tribunal is for the purposes of Section 85, and the tribunal here is defined as the first-tier tribunal. So the new matter provisions do not apply in the upper tribunal. We can now allow the appeal because prima facie, she meets the requirements of 276 ADE, having spent 20 years in the United Kingdom. And this is important for thinking about appeals and appeals in the upper tribunal, where you're thinking, should I ask for it to be remitted to the first tier or should I try and keep it in the upper tribunal? Well, the upper tribunal can consider new matters without having to ask permission of the Secretary of State. So that's an advantage for having things looked at by the upper tribunal. Buci. Buci, again, is an important case. Buci looks at Part 5A of the 2002 Act. These are the statutory provisions for Article 8, Sections 117A to 117D, and about a partner for the purposes of Part 5A. And they note that partner is not defined. And when considering Part 5A of the 2002 Act, Appendix FM, Gen 1.2, and the definition of a partner there, and the whole requirement for things like 2 years cohabitation, doesn't govern the way in which partner should be interpreted for the 2002 Act. Now, they say in Part 2, look, if you meet Gen 1.2, of course you'll be a partner, but if you don't, a judge will need to look at some broad evaluative exercise and assessment of the relationship to see if you are a partner. And partner involves a genuine emotional attachment. And it doesn't necessarily, it's not necessarily be characterized by present cohabitation. Look at paragraph 18 of the judgment. So you don't need necessarily to be cohabiting, but it needs to be something more than just a young person's boyfriend or girlfriend. There needs to be this genuine emotional attachment. And obviously the level of emotional attachment will impact whether a judge finds, in this case, a deportation context, whether it's unduly harsh to be separated from the partner. Even if you're not a partner for the purposes of Part 5A, the relationship would still need to be considered in a deportation context under Section 117C6 when looking at the very compelling circumstances where everything needs to be considered following NA Pakistan. So an important case on the definition of what is a partner. Ellis is a bit more tricky case. It's a judicial review case, and it's about the discretionary leave policy. So the people with the old discretionary leave would normally, the policy says, and this is going to be important, be granted ILR after 6 years, all right? So this guy applied for ILR, but the problem was he'd had a 4-month imprisonment sentence. So the Secretary of State said, well, we're going to give you further DLR, but didn't properly consider that the policy means he should normally be granted ILR. Permission was granted in the JR, and after permission, the Secretary of State did a supplemental decision addressing the discretionary leave policy. Let me tell you the conclusion, and then we'll go back through the reasoning. Mr. Justice Martin Chamberlain found that even though the original decision was flawed because it didn't properly look that somebody would normally be granted indefinite leave to remain under the policy, he wouldn't grant relief in this case because there was the supplemental decision, which was legally sound, and that somebody wouldn't have yielded a different outcome if relief was granted. So he looks at, when interpreting a policy, one must look at the objective meaning that a reasonably literate person would ascribe to that policy. So in the Home Office, look at point 2, Home Office discretionary leave policy, there's that word normally in there. So just because somebody's been here 6 years and the same conditions remaining, that doesn't mean they automatically get ILR. Normally gives the Secretary of State the maximum possible discretion. So the Secretary of State can choose not to give them ILR as long as they take account of the policy and give reasons for adopting a different course. Mr. Justice Martin Chamberlain then goes on and looks at the Court of Appeal decision in Karupan. That governs the sort of issuing of supplemental decisions. And he look at paragraph 3 of the head note of the different types of supplemental decisions you can get in a JR. In this case, it was a fresh decision. The fresh decision can't cure the defects in the original decision, but it can mean that no relief is granted in the JR. They adopted a similar approach to that of the upper tribunal in Kerr, and also relied, look at head note 4, on section 31(2)(a) of the Senior Courts Act, which says, you know, relief shouldn't be granted if the outcome would not have been substantially different unless 31(2)(b) applies, where there's some exceptional public interest. So that's Ellis. Imran is another deportation case. This follows very much the line of PG Jamaica in the Court of Appeal. In a number of my other videos, I've talked about unduly harsh and what needs to be established under the current case law, but this sort of hammers it home. Again, it's Mr. Justice Martin Chamberlain. So in applying exception 2 under section 117C and the unduly harsh test, where you've got a child has got 2 parents, evidence of the particular importance of one parent or emotional dependence or the emotional harm that flows from separation will not be enough to justify unduly harsh without something more. But that without more is a fact-sensitive assessment. So when arguing cases on unduly harsh grounds, don't just say, well, look, there's going to be emotional harm from separation from a parent who is very close to the child. You're going to have to show that something more to get home on that unduly harsh test. Mujahid again, we're going to look at 2 more cases now that deal with rights of appeal. Mujahid was one of my cases. It involved somebody applying for ILR but being refused on tax discrepancy grounds. But in the decision letter refused the ILR application, but said, well, you've got a 7-year child, so we're going to grant you limited leave to remain. A notice of appeal was submitted to the First-tier Tribunal saying, well, the refusal of ILR represents the refusal of a human rights claim. The First-tier Tribunal refused to accept that there was a valid appeal, and there was a judicial review application challenging the decision of the First-tier Tribunal. And the President, Mr. Justice Lane, said this: a person C in the United Kingdom who makes a human rights claim is asserting that C, or somebody connected with C, has, for whatever reason, a right recognised by the European Convention, which is of such a kind that removing C from or requiring C to leave would be a violation of that right. So that's what a human rights claim is, that if you remove me or require me to leave, that would be a violation of that right. The refusal of a human rights claim under Section 82 involves the Secretary of State taking the stance that they're not obliged to grant leave under the Human Rights Act. So accordingly, where the Secretary of State decides to, the Secretary of State does not refuse a human rights claim, where they grant limited leave by reference to, say, family life, even though they've refused on another basis. So effectively they said, well, we've granted you leave, so there's no refusal of a human rights claim, even though we'd argued, well, the refusal of ILR was in itself a separate refusal of a human rights claim. That the President said, no, they've responded by granting leave, so there is no refusal of a human rights claim in this case, and therefore no right of appeal. On a similar issue, we look at MY. MY was a domestic violence case. And in that case, the First-tier Tribunal had found that there was no refusal of a human rights claim. And it was one of those decisions, or I think in a supplemental letter, the Secretary of State had said, well, if you want your human rights considered, make a paying human rights application. The President again says this: the Secretary of State's assessment of whether a claim by C constitutes a human rights claim, as defined by Section 113 of the 2002 Act, is not legally determinative. So it's not for the Secretary of State to determine whether you've made a human rights claim. However, their guidance is broadly compatible with the jurisprudence, see head note 1. But the fact you've made a human rights claim, head note 2, doesn't mean that where it's refused, there's automatically a right of appeal. In order for there to be a right of appeal, head note 3, the Secretary of State has to engage with the claim and reach a decision that nobody's entitled to remain in the United Kingdom as a result of the claim. So very much dovetails with Mujahid. In this case, it was argued, well, look, we made a human rights claim in our domestic violence application. The fact that that has been refused is a refusal of a human rights claim and there's a right of appeal. The President said, no, there's been no engagement with that. Therefore, there's no right of appeal. Nimo, let's change subjects a bit and go to disclosure in the context of a EEA marriage of convenience case. In this case, we see another example of the current leadership of the Upper Tribunal rowing back from some of the decisions of President McCluskey. In MIA, in 2014, President McCluskey held that fairness required the disclosure of the interviewer's comments, which are on form ICD 4605. So it's not just the interview record, it's the comments that go to the decision maker. And in MIA, the President found they were required in order to have a fair hearing. And the Upper Tribunal in this case, and the President found, well, no, MIA confuses judicial review with statutory appeals, and in an immigration appeal, the Secretary of State's duty of disclosure is not to knowingly mislead, and there's reliance upon CM and Karouche, which set out the jurisprudence. So actually, Rule 24 of the procedure rules does not routinely require the disclosure of the ICD 4605. And then finally, some country guidance. Now, again, I've done a video on this. Members of my chambers have also done a discussion video covering Iranian country guidance. So I'm just going to touch upon this. This replaces former country guidance on Iranian conversions. The first issue, paragraph 3, is whether somebody's a genuine convert. So that's the first thing that's going to have to be decided. If somebody is genuine and they're going to openly practice their faith in Iran, they would be at risk of persecution. The Secretary of State had tried to argue in the decision, well, some minor detentions don't amount to persecution, and that's roundly rejected by the Upper Tribunal. What about if somebody would conceal their faith? Well, if any part of their reasoning is to avoid persecution, they're still a refugee, 3 Roman 2. But if they conceal for purely other reasons, 3 Roman 3, that would not entitle them to refugee status. What about somebody who was not a genuine convert? Well, normally there wouldn't, head note 4, be a risk in Iran for somebody who's not a genuine convert. But what about on this pinch point of return that other cases have talked about? Well, if you divulge that you've claimed to be a Christian, you're likely to be taken for further questioning. You might have to sign an undertaking to renounce your faith, but that won't involve a real risk of ill treatment. But there may be cases where there could be a risk, and there are some factors in Roman 4A to D. And look at D, overt social media content indicating that the individual concerned has actively promoted Christianity. So even if you're not a genuine convert, but there's that overt social media activity, that is something that might put the non-genuine convert at risk. So that's been a whistle-stop tour of a very busy month of February 2020. As I said, I'll try and put these slides on the website, and underneath this video, I'll put the links to the decisions of the Upper Tribunal so you can have a look at them further. I hope that's been helpful to you, and I look forward to speaking to you soon with my March 2020 update. Thanks a lot.